According to Section 37 of the Act, a female employee who has worked for the company for at least 90 days in the 9 months prior to giving birth is entitled to 98 days of maternity leave in a row. Additionally, the law allows maternity leave to start up to 30 days before the anticipated birth date. Additionally, the leave may start even early if a licensed medical professional determines it is required for health-related reasons. It is obvious that Normala's circumstances comply with this legal requirement. Due to health issues, her doctor advised total bed rest and she asked to begin her maternity leave 7 days prior to her due date. This requires satisfy the legal requirement for an early start of maternity leave since it falls within the allowed time frame and medically justified. According to a study by Nur Shuhadawati Muhammad Amin and Nur Hafizah Muhammad Badrul Afandi in 2023, Malaysia's constitution protects the value of equality and non-discrimination in the workplace, strengthening the legal protection for a female employee during a maternity leave. Her boss, however, took issue with the time of her departure, pointing out that it might affect performance. Such objections have no effect on the employee legal right. Termination or discrimination based on a pregnancy or maternity leave is especially forbidden by the Employment Amendment Act 2022. In conclusion, Normala request to start her maternity leave early was supported by medical documentation and fully comply with Malaysian labour legislation. In spite of lacking a valid reason, her employer opposition ran the risk of breaching the legal safeguard provided to maternity workers.
Under the Employment Act 1955 as amended by the Employment Amendment Act 2022, female employees in Malaysia are granted essential protections related to maternity. One of the key provisions is the entitlement to 98 consecutive days of paid maternity leave. This leave can commence as early as 30 days before the expected delivery date. To access this leave, the employee must notify her employer at least 60 days before the expected confinement if reasonably possible. During the maternity leave period, the employee is entitled to receive a maternity allowance unless she has 5 or more surviving children as outlined in Section 37, Subsection 1, Clause C. According to Section 37, Subsection 2, Clause A, 1 Roman and 2 Roman, the employee qualifies for the allowance if she has been employed for at least 90 days in the 9 months before her confinement and she has been employed by the current employer at any time within the 4 months immediately before the confinement. Under Section 37, Subsection 2, Clause B to Clause D, a qualified female employee is entitled to receive a daily maternity allowance throughout her eligible period. This allowance must be paid at her regular daily wage or at a rate set by the minister, whichever is higher. If she paid monthly and continues to receive her full salary during maternity leave without deduction for her absence, she is considered to have received her full maternity allowance. However, if an employee claims maternity allowance from multiple employers, the total amount must not exceed what she would have received from just one employer. Under Section 41A, Subsection 1, explain that if an employee is entitled to claim maternity allowance from more than one employer, the employer who pays can recover a fair share of the cost from the others. This recovery is based on the proportion of days the employee worked for each employer during the 9 months before delivery. This reimbursement can be pursued as a civil debt. In the case of the employment termination, under Section 41A, Subsection 2, it is the employer's responsibility to prove that the dismissal was not due to the employee's pregnancy or any related medical condition. Lastly, under Section 60F, Subsection 1, Clause AA, if the employee remains unwell after maternity leave and has a certified medical condition, she is entitled to paid sick leave, where employees with less than 2 years of service receive 14 days per year. Those with 2 to 5 years get 18 days, and those with over 5 years of service are entitled to 22 days per calendar year. If an employee is certified as needing hospitalization but is not actually hospitalized, she is still considered hospitalized for the purpose of this entitlement.
Under the Employment Act 1955, Normala termination is both unlawful and unfair. Section 41 Clause 1 prohibits terminations during maternity leave or absent under Section 37. As of 1 January 2023, employees are entitled to 98 days of paid maternity leave. Normala began her leave 1 week before delivery, which is legal. Her employer's objections and subsequent termination are in violations of Section 41. After maternity leave, Normala was diagnosed with postpartum psychosis and given 1 month of certified medical leave. Section 60F grants up to 60 days of paid sick leave per year for hospitalizations, in addition to maternity leave. Her termination during certified medical leave breaches her legal rights under the Employment Act 1955. Section 20 of the Industrial Relations Act 1967 allows employees to challenge unfair dismissal within 60 days. Dismissing Normala due to her postpartum condition may be viewed as gender-based discrimination. Such dismissal contradicts industrial law principles and may not be legally justified. In Dr. Koei, Aihua against Flextronics 2008 and Jennison against Sony 2006, the courts ruled that termination due to post-maternity health issue is unfair unless the employee is permanently unfit and due process is followed. These cases affirm that fair assessment is required before dismissal on medical grounds. In conclusion, Normala's dismissal violates the Employment Act and may be discriminatory under the Industrial Relations Act. She has valid grounds to file for unfair dismissal and may seek reinstatement or compensations. The law protects female employees during the maternity and illness, and employers risk legal action if they fail to comply.
Social Security coverage helps to protect the right of every employee from any unfair treatment or accidents that occur at the workplace. A good Social Security in the workplace can ensure greater Social Security benefits for employees. The first Social Security benefit available for Normala is the maternity leave. Normala can take or extend her maternity leave to give her the chance to rest and taking good care of her newborn. During this period, she is provided with protection and income security which are mandatory to be followed by the company. This ensures Normala to protect her right as an employee while maintaining her salary to support her financial sources during the maternity leave period. Secondly, the Social Security benefit available for Normala is the medical care benefits. She can claim the medical scheme to ease her burden in financial the medical treatment costs for her confinement with evidence from her medical certificate. Besides, Normala can claim the medical insurance if she is a registered member under SOCSO and able to extend her maternity leave period.